Hi there, I'm Marie-Françoise Wald.
And I'm Kevin Harris.
And welcome to this online video presentation, the UK Bribery Act 2010, What You Need to Know. Let me tell you, first of all, what this training session covers.
We're going to be asking and answering the following key questions. Why has the Bribery Act been passed? What are the offences under the Bribery Act and the sanctions and penalties which apply? Where does the Bribery Act apply and who does it apply to? And finally, what are the key differences between the UK Bribery Act and the United States Foreign Corrupt Practices Act?
So why a new Bribery Act and why now?
There was a growing realisation that the British laws on corruption weren't modern enough. In 1977, the United States had passed its Foreign Corrupt Practices Act, which criminalised the payment of bribes by US executives and companies to foreign government officials, something which wasn't really covered in Britain. The formation in 1993 of the non-government organisation Transparency International drew attention to the devastating impact of corruption in the developing world. And in 1997, the UK became a signatory to the OECD Convention on combating the bribery of foreign public officials, under which countries assumed obligations to enact tough criminal legislation to combat bribery and corruption.
So a combination of social good, public expectation and sovereign legal obligations made Britain's new Bribery Act essential. And it's important to realise that the Act is very far-reaching and criminalises some activities which, depending on your point of view, you may have never considered to be illegal or even unethical in the past. So what then are the offences which can be committed under the UK Bribery Act?
Well, there are four, which we can describe as
bribing another person or active bribery under Section 1 of the Act, being bribed or passive bribery under Section 2, bribing a foreign public official under Section 6, and a specific offence applicable only to corporations or failing to prevent bribery under Section 7 of the Act.
So let's take a look now at each of these in turn. We'll start with the offence of bribing someone. Under the Act, the offence of bribing someone occurs
when a person, P, promises or gives a financial or other advantage, either A, intending that the advantage induces the improper performance of a relevant function or activity, or B, intends that the advantage rewards someone for the improper performance of a relevant function or activity, or C, knows that the accepting of the advantage offered in itself constitutes the improper performance of a relevant function or activity.
But what does that actually mean in practice? Well, we can make sense of it by looking at some examples.
You are P for Peter. You're competing for a £10 million contract being awarded by your target customer, Rapco, represented by R for Robert. Rapco's procurement rules state that contracts must be awarded to the best bidders, and Robert, of course, owes a duty to Rapco to ensure that the rules are applied. Intending that Robert should ignore the requirement and award the contract to your company regardless, you promise to pay him £100,000. You have committed the offence of bribing someone, right there.
You haven't given him anything, and he hasn't done anything improper yet. You simply promised a financial or other advantage, intending that Robert should award you the contract improperly, and that's sufficient for bribing another person.
It's also, of course, active bribery if you actually pay him the £100,000. As indeed it is if you promise or pay the money after he's awarded you the contract as a reward for that improper behaviour.
What is improper performance? Well, it basically occurs when the receiver, in plain English, acts wrongly. For example,
breaching an expectation that they will act impartially, that they will act in good faith, and that they will honour a position of trust.
Now, we've given the example of someone paying bribes to win contracts, but there's a wide range of situations where the offence could occur.
You might bribe another person to obtain unauthorised discounts on goods and services, or to obtain a lower rate of interest on a bank loan, or to secure the exclusion of a competitor company from a bidding process. Technically, you could even commit the offence if you promise or give something to the house manager in order to obtain a table in a fully booked restaurant.
And there's one other important situation that the Section 1 offence covers.
Yes, imagine
Different circumstances in which you're P for Peter, who is responsible for an important office refurbishment project being undertaken for your company by its contractor, Rapco. Rapco's site manager, R for Robert, tells you that in order for him and his team to carry on working, however, you'll need to pay them a little sweetener of a few $100s each. Desperate to meet a tight deadline, you promise or make the payment.
Is that bribing another person under the Act? After all, you haven't paid for anything improper, have you? Because you're only paying them to do something that they're meant to be doing anyway. These types of payments are known as facilitation payments or grease payments, and many of you will have come across them. They are very common.
Typical scenarios include paying the telephone company engineer to install the phone lines that he's meant to be installing anyway, paying the immigration officer to permit you to enter a country which you're legally entitled to enter anyway on your valid travel documents, and yes, paying a traffic cop not to give you a ticket for a non-existent speeding offence.
So, are they bribery? Well, the answer is yes. In making these payments, you do commit the offence of bribing another person because of those words from the Act which Marie read out earlier.
Where you know that accepting the advantage in itself constitutes improper performance.
In other words, you know that as an employee of Rapco, Robert isn't meant to demand or receive these payments, but you make them anyway. That too constitutes the criminal offence of bribing another person. The financial or other advantage is broadly defined beyond just money and covers both direct and indirect advantages, as well as advantages given to third parties. So it covers, for example,
employment and jobs, cars, holidays, personal discounts, anything, in fact, which provides a benefit to the receiver.
And it doesn't have to be direct.
So, if, for example, instead of paying cash, Peter wired funds from a company account to the account of an agent in an offshore tax haven, and the agent then wired the funds onto a company controlled by Robert, he would still commit the offence. And neither does it have to be Robert himself who receives the advantage. If Peter, for example, purchased first-class air tickets for Robert's wife and daughter to visit Disney World, or made a donation to a charity nominated by Robert,
then you would still commit the offence of bribing someone if you intended that Robert should perform his duties improperly or intended to reward him for doing so. And the penalty for the offence of bribing another person? 10 years imprisonment and or an unlimited fine. So as you can see, the sentencing is designed to provide a very serious deterrent.
Yes, well, so much for bribing someone. But what about being bribed, otherwise known as passive bribery?
A person, R, is guilty of an offence
when R requests, agrees to receive or accepts a financial or other advantage, either intending that a relevant function or activity should be performed improperly, or where the requesting, agreeing to receive or accepting of the advantage itself constitutes improper performance, or as a reward for the improper performance, or in anticipation or consequence of R requesting, agreeing to receive or accepting a financial advantage, a relevant function or activity is improperly performed by R or by another person with R's direction, assent or acquiescence.
This offence, then, is the flip side of bribing someone. Again, let's break it down.
In this example, you are R for Robert, the person at Rapco who is responsible for managing a large contract for the supply of goods to its customer, Palco Limited, represented by Peter. Rapco's rules prohibit the granting of discounts in excess of 10%, but, intending to break this rule and grant a bigger discount to Palco, you accept the offer of a new job at Palco at double your current salary. You have committed the offence of being bribed under Section 2 of the Act, even if you haven't actually given the discount yet. Likewise, if you have already granted a larger discount to Palco and you accept the job as a reward for your action, or if you granted the discount in anticipation of getting the job, then you have also committed the offence.
And it's not just accepting the advantage. In this example, you would also commit the offence of being bribed if you merely requested the job or if you agreed to it in principle. As as with the offence of bribing another person, the financial or other advantages in question here can be wide-ranging and would include, for example,
having your hotel bill paid, the use of a free holiday villa, the award of a contract to your partner's company, giving a job to your son or daughter, as well, of course, as expensive meals and entertainment.
And as with bribing another person, the offence of being bribed carries a maximum sentence of 10 years imprisonment and/or an unlimited fine.
OK, so far we've looked at the offences of bribing someone and being bribed, which both require the improper performance by someone of their job or function. And if this key element of improper performance is absent, then no offence is committed. Now that's important because it excludes normal corporate hospitality from criminalisation.
As long as the hospitality in question is allowed under your corporate code of conduct, and as long as there is no intention that anybody should, say, breach trust and make decisions unfairly and in bad faith, then normal corporate events, sponsorship and entertainment between commercial organisations is normally perfectly okay.
Although, if you're in any doubt, you should of course check with your compliance department. But hospitality does become problematic under the Bribery Act, where foreign government officials are involved.
Indeed, because the third offence created by the Bribery Act, that of bribing a foreign public official, has a different, lower threshold, triggering the commission of the offence.
Under Section 6 of the Act, a person, P, is guilty of the offence of bribing a foreign public official, F,
when P offers, promises or gives a financial or other advantage to a foreign public official, F, in circumstances where P intends to obtain or retain business or an advantage in the conduct of business and intends to influence F in his or her capacity as a foreign public official.
So nothing there about inducing improper performance. When you provide a benefit to a foreign public official, all that's necessary for you to be convicted of bribing that official is that at the time when you do it, you intend to obtain or retain a business advantage and you intend to influence the foreign public official in their official capacity.
So in this example, Peter's company Palco is awaiting the outcome of an important business licence application, which will be decided by F for Ferdinand, a public official in that country. Peter remembers that Ferdinand enjoys golf, and so he invites Ferdinand to fly with him to a golf hospitality day at his luxury island golf club, followed by an expensive meal. At no point does Peter ever intend that Ferdinand should make his decision improperly, but he does try to influence Ferdinand's thoughts on the matter in the hope that Palco can obtain the business benefits which flow from the grant of the licence. In this scenario, Peter has committed the offence of bribing a foreign public official, regardless of whether or not Ferdinand actually goes on to grant the licence.
Of course, this is a much lower standard and it potentially criminalises all hospitality given to foreign public officials, so you need to be extremely careful about the way in which relationships and meetings with such officials are conducted. And the penalties? Again, as with the first two offences, the maximum penalty for bribing a foreign public official is 10 years imprisonment and/or an unlimited fine. One last point to note about all three of those offences, bribing someone, being bribed and bribing a foreign public official, is that they can also be committed by the organisation that the bribe payer or bribe taker works for, if it can be shown that the acts in question were undertaken by a directing mind of the company, such as a board director. And if the offences have taken place with the consent or connivance of a senior officer, then the senior officer in question would also be personally liable and vulnerable to prosecution and conviction.
And the fourth and final offence under the UK Bribery Act 2010 is that of failing to prevent bribery. This is a corporate offence, which means that only corporations can be convicted of it, not individuals. The offence is committed
when an associate A of a relevant corporation C bribes another person, within the meaning of the Act, intending to obtain or retain either business or an advantage in the conduct of business for C.
And what's really tough about this offence is that it doesn't require any intention of the company to commit bribery.
So if one of PowerCo's associates, an employee or agent, let's call her A for Alina, pays a facilitation payment to a foreign public official to issue an inspection certificate in relation to legally importable goods, then PowerCo is automatically guilty of failing to prevent bribery.
And as we'll see, this offence is really important if you're a non-UK company with, however, some kind of presence inside the UK. The penalty is an unlimited fine, and the only defence which a company has in these circumstances is if it can demonstrate that it had adequate procedures in place to prevent bribery. What does that mean? Well, the UK government has published guidance on what it calls the 6 principles for preventing bribery. And these are:
that commercial organisations must have proportionate procedures for preventing bribery, which must be clear, practical and accessible, and effectively implemented and enforced. That there must be top-level commitment to a zero-tolerance policy of bribery, from the board and senior management downwards. That commercial organisations must assess the risks of bribery in their business operations in advance. That there must be effective due diligence conducted against business partners and new business opportunities in relation to bribery and corruption. That commercial organisations must ensure that their policies and procedures are embedded and understood throughout the organisation through internal and external communication and training. And finally, that the organisations must monitor and review compliance with its own bribery prevention policies and procedures and make improvements where necessary.
So what then about jurisdiction and applicability? Where does the UK Bribery Act apply, and to whom?
Yes, well, here we have to distinguish between, on the one hand, the offences of bribing another person, being bribed, and bribing a foreign public official, and on the other hand, the corporate offence of failing to prevent bribery.
In relation to the first 3, these offences are committed
where any part of the offence took place in the UK, or where all parts of the offence took place outside the UK, and the action in question would constitute an offence if it took place inside the UK and it was committed by a person with a close connection with the UK.
The phrase close connection to the UK basically means UK citizens and companies incorporated in the UK and any individuals ordinarily resident in the UK.
So, if you're the British employee of a UK incorporated company who pays or accepts a bribe inside the UK, then you, and if you're senior enough, the company, can be convicted of bribing another person or of being bribed. If you're the British employee of a UK company operating in, say, Russia, and you pay or accept a bribe there, or anywhere else in the world, then again you can be convicted under the Act. And the same would apply if you were, say, an American or an Australian resident in the UK, working either for a British company or for the UK arm of your parent company.
If you pay or receive a bribe, whether inside or outside of the UK, you're going to be guilty and liable to prosecution. The situation is different, however, for the Section 7 corporate offence of failing to prevent bribery. For this offence, there is no requirement for a close connection to the UK, as it's defined in the Act. So not only do British companies commit the offence if there's bribery in any of their operations anywhere in the world,
but also if you're, say, a Chinese company whose employees or associates pay bribes either within or even outside the UK, say in return for the granting of a quarrying and mining concession in Africa, then if your company has any kind of presence in the UK,
it can still be prosecuted here for failing to prevent bribery.
So you'd better have those adequate procedures in place.
Absolutely.
OK, to close up. Now, some of you may already be familiar with the provisions of the United States Foreign Corrupt Practices Act, or the FCPA, and may indeed have been complying with it for years. So are there any differences between the Bribery Act and the FCPA? Well, the answer is yes. The Bribery Act is actually even tougher.
The FCPA focuses on the bribing of foreign government officials, whereas the Bribery Act specifically covers all acts of bribery, including those between private companies. The FCPA has a specific defence for facilitation payments, whereas, as we've seen, the Bribery Act has no such defence, and facilitation payments are effectively treated as bribes. The FCPA has no corporate offence of failing to prevent bribery, whereas the Bribery Act does. And finally, whereas the maximum sentence under the FCPA is 5 years imprisonment, as we've seen, under the Bribery Act it is 10 years.
Yes, and it's also worth remembering that apart from criminal prosecutions of individuals and companies,
the UK prosecuting authorities may also seek civil recovery orders under which companies could find themselves having to pay back substantial amounts representing the proceeds of contracts which have been won through bribery. Not only that, but conviction of a bribery offence could also lead to them being debarred from public sector contracts.
So if there's one message which comes out loud and clear from this piece of legislation, it's that bribery simply isn't worth it. That concludes this online video presentation on the Bribery Act 2010. Thank you for watching.
And of course, if you want to learn any more, simply visit www.antibriberyvideos.com. Goodbye.